Justice Gustafson, can you hear us and see us okay?
Thank you.
All right, good morning, everybody. This is time for oral argument in cause number DA 25-0409. Steve and Roxanne Blanchard versus Wild Horse Trading Company, L.L.C. and others. And I believe if council could briefly just introduce yourselves and who's going to argue, that'd be, before we start, that'd be helpful. All right, and then are you reserving any time?
Yes, Your Honor, I'll do my best.
We'll try to wreck your plan. So. All right, counsel, whenever you're ready.
Morning, and thank you, Mr. Chief Justice, and may it please the court. At issue in this case are two specific forms or two species of negligence. We have direct negligence, which focuses on the conduct of PacWest, and we similarly have vicarious liability.
We can't hear him.
Okay, we're having a hard time hearing you. That microphone may be,
Can you hear me now, Justice Gustafson? Not at all? Can't hear me. How about now? We just switched microphones. All righty.
all right, proceed.
So we have direct liability, which focuses on the conduct of PacWest, and the duty in those circumstances turns primarily on foreseeability, of course, as it does in all cases of negligence. And we also have vicarious liability. And that discussion I'll get to second, which will bring us into the discussion related to the Beckman cases, the Beckman case and Paul and so forth. So with respect to plaintiff's direct negligence claim, I want to start with three basic principles before I get into the district court's order. First, and this is from Nelson v. Driscoll, there's a long-standing principle of tort law that one who acts has a duty of acting carefully. When you act, you have a duty to do so carefully. Second basic premise, duty is measured by the scope of the risk. The question is whether a defendant reasonably could have foreseen that its conduct could have resulted in injuries to the plaintiff, though the specific injury not need be foreseeable. That's from Gourneau and various other cases dating back to Busta. And third, and importantly here, where there is a question as to whether the act of a third party in causing harm to the plaintiff is foreseeable to the defendant, that is a fact-intensive inquiry, not typically susceptible to summary judgment. That was the case in Fisher v. Swift, which is discussed in our briefing, and then later affirmed again by this court in SW v. State, which came after that. So we're here because the district court determined that PacWest had no duty to Steve Blanchard when it sent him to Clark Fork to pick up a load of log bundles at the sawmill. So taking a step back for a moment, we certainly can't pretend that PacWest would never owe a duty to Steve Blanchard where it sends him somewhere. For example, had PacWest contacted Steve and told him to go pick up a load of lumber at a place and time where PacWest knew there would be dynamite operations, for example, right? That would be negligent. And why? Well, because injury is foreseeable. There would be a duty there. So why did PacWest send Steve to pick up the log bundles at this place and time in this instance? Well, PacWest contracts with Clark Fork Post, who you've read about, to cut the logs, to bundle these log bundles up, and then importantly, and the most important thing we're going to talk about here, is also then to load them. PacWest also contracts with Steve Blanchard to bring that load to Frontier, who's another contractor of PacWest, who then treats the lumber. But I want to focus on the loading because that is the inherently dangerous activity. That's what caused the injury here. That's what we're here about. That loading is part of the contract with Clark Fork, where PacWest contracts with Steve Blanchard, who's an independent contractor of PacWest. They send Steve Blanchard with a semi-truck capable of carrying this enormous weight. But he can't, I mean, they weigh 7,000 pounds apiece. Steve Blanchard can't lift them up, and he doesn't have the equipment to do that. That is part of the service in the contract with Clark Fork, as between Clark Fork and PacWest. And PacWest has contractual
Mr.
arrangements.
Stalpus, could I
Yes.
ask you a question about
course.
that contract between Clark Fork and PacWest to provide this service?
Yes.
Does that make Clark Fork an independent contractor of PacWest?
Absolutely. Yes, it does.
So, because it seems like a big issue in this case is the parties' disagreement about that. And first of all, do both your theories depend on Clark Fork being an independent contractor? And second, what makes Clark Fork an independent contractor of PacWest here?
Justice Baker, I appreciate that. So I'll take them in turn. Number one, first, the answer to your first question is, do both theories, direct liability and vicarious liability, depend on the status of independent contractor contractee? The answer to that is no, and here's why. So we can look at, for example, Fisher v. Swift, as one example discussed in the briefing. So in Fisher v. Swift, the basic facts are,
So before you do that.
Yes.
So which theory does not depend on that status?
thank you, the direct negligence theory. So under direct negligence, the status of PacWest and Clark Fork does not need to be a contractor-independent contractee relationship.
Okay, go ahead. Go ahead with Fisher, sorry.
Yep. So in Fisher, law enforcement officer Fisher was responding to an incident. A semi-truck had gone off the road because the allegation was a semi-truck driver was driving negligently by proceeding in a significant snowstorm. So in the aftermath, a tow company released the winch that it was pulling the tractor and negligently released that winch. The tractor and trailer slid and pinned Fisher between his patrol car and the trailer. Now, Fisher sued Swift, alleging that his injuries were a foreseeable consequence of driving through the snowstorm. Therefore, there is a duty. Swift argued there's no duty because it's unforeseeable that the tow company would negligently release the winch, and in any case, Swift has no control, no relationship whatsoever to this tow company, right? Well, the court found there was a duty because it doesn't turn, whether there's a duty in a direct negligence claim does not turn on the status of these parties, right? It turns on foreseeability. Is the action of sending Steve Blanchard to Clark Fork, is injury to Steve Blanchard a reasonably foreseeable consequence of that act? As to your second question, Justice Baker, which is the independent contractor relationship with respect to the vicarious liability claim. And I will be coming back to this. I'm going to answer it shortly, but I think we'll be coming back and retreading this ground. There is no dispute, really, that there is a contract between PacWest and Clark Fork Post. There's testimony from Steve Wern, a management level individual from PacWest, the only individual from PacWest to testify, and I'll read this testimony here for you. The question was, PacWest has contractual relationships with Steve Blanchard, Frontier Post, Clark Fork Post, and Frontier Wood Preserves. Is that correct? Answer, correct. There is a contract. At oral argument, in this case, when we had it before Judge Venata, page 19, lines 8 through 10, PacWest counsel said, PacWest does not dispute that it has a contractual, that it has contracts with Clark Fork Post. So we have a contractual relationship.
But what's the nature of the contractual relationship? We basically have two theories here. We have subcontractor and we have customer. So purchaser contract is still a contract. Mm-hmm. That's where I'm looking at the undisputed facts section of Judge Venata's order. And he's saying PacWest hires Steve Blanchard as independent contractor to haul logs, but the relationship with Clark Fork is a purchase contract relationship. That's the question.
Sure. Okay. Well, let me address that, because PacWest does argue it's simply one of Yoder's customers, right? But that ignores the reality of what's happening here. If I go to Lowe's and buy some posts, that's one thing, right? Here, this is a totally different arrangement. PacWest is a sophisticated lumber distributor that serves as an intermediary. It has these contractual relationships with these entities, and talking specifically here with Clark Fork, PacWest buys up, testimony was not all, but substantially all, the majority of Clark Fork's inventory.
So what is the difference between this and the customer at Lowe's?
Sure.
Where is the line drawn between the customer at Lowe's who may buy one load of poles a year or two
Right.
versus a more sophisticated
And the
buyer?
Yeah, and the restatement gets, well, that's part of it. That's part of it. And the restatement sections 411, 416, and 427 all discuss that the sophistication of the entity that is entrusting the dangerous work matters.
Excuse me, when you turn away from the mic, it doesn't pick up
Oh,
your
I'm
voice.
sorry.
I don't know.
Sorry, Gary. The sophistication does matter as far as the level of inquiry. But I think getting to your point, Justice Rice, you're asking where is that line? And here's the difference. If I go to Lowe's and I buy some posts, I am not engaging someone to, I'm not engaging.
You have a contract.
I have a contract,
Yeah.
no doubt, right? But I am not engaging someone to engage in an inherently dangerous activity, which we have engineers, we have equipment manufacturers that all deal with this situation of loading these kinds of posts. This is a very unique thing that does not happen at Lowe's. So what are the standard?
Doesn't the purchaser at Lowe's, by his purchase, incentivize somebody to do this very dangerous activity of loading the poles at Lowe's? And
I hear what you're saying, but you can't do this at Lowe's. So this is a situation where at Lowe's you don't see cherry pickers. At Lowe's you don't see the steel dunnage that is required to do this job safely. So let's talk about those, because
well,
these
you
are
probably see them when they unload the poles from the truck to the store. I mean,
well, it could be.
unloading
I
a
don't-
load of poles into the store could fall and hurt somebody.
Well, I don't, if we're to go down the road, I would say that the customer, if I go to Lowe's, I have nothing to do with that. Whether there may be something, I don't know how
And
they're,
that's what PacWest argues. We had nothing to do with that.
well, they had everything to do with sending Steve to this site. They had everything to do with contracting with Clark Fork. So they knew Clark Fork can't operate machinery. And they know, because they've been to the site, that the machinery that is typical for this sort of arrangement. So we have
The
these.
difference is knowledge. The customer at Lowe's doesn't have knowledge.
That's a big difference, yes. And that's built in and baked into those restatement sections.
Well, and that kind of goes back to your original point about foreseeability then, doesn't it? I mean, if you've got an ongoing relationship, the nomenclature that's being used in terms of contractor and subcontractor is less important than the foreseeability or the knowledge, as Justice Rice alluded to, because there's an ongoing relationship or at least a repeated relationship.
Absolutely. And I think what you're touching upon, Justice Shea, is the law behaves most poorly when we overly focus on labels and not relationships and foreseeability.
So let me ask another hypothetical.
Please.
What if I like oysters? And I want to go to this restaurant in this coastal state and I know, as a frequent customer, that they're shucking oysters in the back by hand, and that's if you're not careful, you lose a finger for that. But I keep going back to that restaurant and purchasing that product with that knowledge, and in fact, I even say to the owner, reserve me a table every Friday night because I want to come, and even though I know your guys are cutting off their fingers in the back, I mean, do I have a liability then because of my knowledge and my ongoing relationship and my contract with the restaurant?
Of course you don't. No.
What's the difference?
Here's the difference. What we have here is there are things that we do in life that are what we call dangerous. It could cause you to even maybe, I mean, I don't know what the statistics are on cutting off fingers with oyster shucking. I know nothing about it. However, this is a totally different species of danger and a totally different species of arrangement. So for example, we do treat trenching differently, right? The Beckman case focuses on this and says there are significant and serious dangers that are pertinent to doing this type of work if it's not done with the industry precautions that are necessary to do this. People could be killed, people could have spines broken, people can be buried alive. And the same is true for this specific act of loading. This isn't a post, this isn't something you can lift. This weighs close to, this is more than 3 tons. This requires very specific equipment to do safely, which, by the way, exists now on the site and didn't exist before. And I think that's another thing that comes to this, and we see this in docket 82. There's deposition testimony in this case. Here's what also sets it apart, right? So you make a dinner reservation every Friday night, that's one thing. However, you're not making capital loans to keep this business afloat. That is happening here. PacWest is making capital loans to Clark Fork Posts. Now, there's a dispute in the testimony over whether Mr. Yoder says that capital loan came before this incident, and Steve Wern says this happened afterwards. But here's what's undisputed. After the capital loan, whether it's shortly before or shortly after the incident, after the capital loan, the requisite equipment shows up on site. The cherry picker shows up on site, which is necessary to do this job safely. The steel dunnage, now these are those U-shaped, we have a picture of them in our brief, those U-shaped steel things that are engineered to take the cherry picker crane and set the log bundles within the semi-load. Those are there and are used regularly now. So these industry precautions are used now. Again, we found out about these shortly before summary judgment. We didn't have a chance to analyze that and dig more into it. We just didn't have discovery in the case because summary judgment came early. But there's but one example, too, that would distinguish this factual scenario. Because what we don't want, I think what you're getting at, is we don't want a rule to come out of this case that would then make anybody who walks in and buys a pole at Lowe's to be dealing with some upstream manufacturing issue. I don't disagree with that at all. I completely and wholeheartedly agree. And here's what we have refrained from doing in this case. PacWest serves as a lumber intermediary. It has upstream commercial clients who know nothing of this situation at Clark Fork Post, who know nothing of the fact that the loading area is too small, is ill-maintained, because after all, this is an Amish facility not set up for vehicle traffic, that it doesn't have the requisite equipment, it doesn't have those standard safety precautions that were in place. We didn't sue those upstream manufacturers who ultimately purchased this post. They're not involved in this. PacWest is.
So counsel,
Yes.
Mr. Stolpis, can you move that microphone toward the middle? Maybe,
Oh, I'm
I don't know
sorry.
why it's, just the whole thing
Move the
slide it
stand,
to the
yeah.
middle.
Oh, right here?
Yeah, thanks.
All right. Sorry.
you started off with your argument saying there's 2 theories, of direct negligence and the vicarious liability.
Yes.
I feel like we're getting a little muddled between some of that. Could you navigate the path for the direct negligence claim? And I think you were starting to get to that, and
Absolutely. And the central question on direct negligence is foreseeability, as far as duty goes, right? So the question is, does PacWest have a duty? And the central question, which doesn't appear in the district court's order, we're focused on.
I was going to ask you that as well.
Yeah, in the district court's order, we're focused on whether there's an agency relationship. That is purely and 100% vicarious, and that's one species of vicarious. But foreseeability is the fulcrum. That is the tipping point always for duty in this state.
And was that put before the district court, the direct negligence theory, or?
Yes, and it was framed as negligent. I mean, it was framed as negligent selection of a contractor, because that's what we were told Clark Fork is a contractor. But it was pled just as we pled an ordinary negligence case. We also pled vicarious liability within that. but the ordinary general principles that would apply are there. The negligent selection of a contractor informs that, and really what it gets to is what I like about negligent selection of a contractor, because they are at least some sort of a contractor, is it does import in section 411 of the restatement this obligation where you are sophisticated to do some level of investigation. And that investigation did happen. Steve Warren appeared on site, he toured it. Another business partner, Matt Troyer, who runs Frontier Posts, he visited the site and saw that all of these dangers are open and obvious.
That gets back to my first question about whether your theory requires an independent contractor relationship, because 411 of the reinstatement talks about an independent contractor.
Sure. And the direct answer, the most direct answer to your question is it does not require an independent contractor relationship because this is a third party. So if it was reasonably foreseeable that sending Steve Blanchard to the Clark Fork facility would cause him injury, and that injury is caused by a third party, we see from Fisher v. Swift, where there is no relationship whatsoever, then there is no independent contractor relationship there. So it's not necessary. However, we've framed this to a certain degree as far as negligent selection of a contractor because we were told they were a contractor.
But
So
is,
that, and I think this is a little different than how your brief is organized, and maybe I didn't catch it there, but the direct negligence claim doesn't involve the Beckman exceptions, really. I mean, it's just a straight,
Right.
I knew that there was, I foresaw danger to the driver of this vehicle, and I breached my duty, just straight negligence, right?
Yes. Yeah, no, exactly right. And then there's obviously causation questions that are even trickier, but those are for the jury.
the counsel, the negligent selection is a different claim than just direct negligence.
Negligent selection is a direct negligence claim. It is so within direct negligence, there is just ordinary, direct negligence is a negligent act, and foreseeability always applies, whether it's negligent selection of a contractor, whatever your theory is. Duty is defined by foreseeability in this state.
It has,
Negligent.
okay, so could you go back and do the path for the direct negligence?
So the path for direct negligence is PacWest owes a duty, and the reason that they owe a duty is because it was reasonably foreseeable that Steve Blanchard could be injured by sending him to the Clark Fork site, because PacWest, who is a sophisticated entity, is aware, due to its sophistication, that the standard industry precautions, such as a crane, such as the steel dunnage, were not in place. Because those standard industry precautions, which are necessary to mitigate these significant risks, were not in place, this requires even more dangerous work. For example, it requires Steve to ratchet down, or somebody to ratchet these down with ratchet straps to keep them in place. It requires the use of loader equipment, which the Amish can't use, but they're going to have to use somebody. But those are always more dangerous than these cherry picker cranes. So because those weren't in place, they knew or should have known that there was a reasonable likelihood of injury. That is the path.
Okay.
But that's really a claim against SUBATCH.
So
The allegation is he or his employee didn't correctly load the
right,
logs.
right, yeah.
Your theory is that it wasn't even the site itself. Your theory was that they didn't use the cherry picker, they didn't have the braces. That was the person loading, right?
So the site itself is very important.
Okay.
The site itself, and in fact, PacWest agrees it's dangerous. They sued Clark Fork for how dangerous their site is. The site is dangerous because it doesn't have this equipment, and it's just ill-maintained. There's mush all over the place on top of clay. There's debris everywhere. So it's dangerous. Because it lacks those standard industry precautions, which appear after the loan, then they need to bring somebody else in. Now, this is going to be dangerous, this active loading, regardless of who is retained to do it. Whether you have Wild Horse or anybody else who's competent, this nevertheless brings significant risks. That's why you're not supposed to do this particular job without these precautions.
Okay, so you've got a causation, maybe even a comparative negligence issue there. I'm back to the question of if they're purchasing. Now, you're saying after the accident, a capital loan came in and some subsequent remedial measures came in. But at the time of the accident, I'm back to, does PacWest have a duty when they purchase logs from someone to then go supervise the operations of that seller? And the seller himself isn't even the one loading it. They've contracted with someone else to load it. So we've got about 4 links in this chain.
Yeah, and there's a couple different parts to that, so let me take them in turn. With respect to the purchase, again, this is more than just the purchase because we're also contracting for the loading, which is the extremely dangerous activity. Clark Fork is responsible for doing that pursuant to the contract, and that is an inherently dangerous, extremely dangerous activity. So there's that. So it's more than just picking up a cart full of goods at Lowe's. And I'm trying to remember all the aspects of the question. Because injury is foreseeable to Steve Blanchard because the standard equipment isn't there necessitating a loader, there is foreseeable risk of harm. There's direct negligence. Because Clark Fork doesn't have this equipment, there's also negligent selection of a contractor, which is part of direct negligence, one of the ways to get there. But it is just ordinary negligence, both of them. With respect to the I think what you're getting at now is the downstream when we talk about Wild Horse. And I haven't had much time to talk about vicarious liability, but what vicarious liability does is it talks about the non-delegable nature. So I think what your question was is, do they have a duty to go out there and supervise? Well, the law is very clear on this point that they can, if they wish, go out there and supervise. If they don't, where there is an inherently dangerous activity and you entrust someone to do work that is inherently dangerous, you do so at your peril. That was the case in Paul versus Park County. Now, AEI, it's clear in paragraph 13 of that decision, there is no control retained, exerted, or whatsoever with respect to that contractor, but there is an inherently dangerous activity. Now, the state said we didn't observe that, we didn't control them, we had nothing to do with this. And this court said, well, when you engage someone, when you entrust someone to do inherently dangerous stuff, like loading of these log bundles, then you need to make sure that precautions are in place to do this responsibly. Because what we don't want in this state, the public policy of this state that informs Beckman, but going all the way back, we have Ullman, we go back to the 1900s, is what we don't want is someone entrusting work to another to do inherently dangerous work that is likely to cause harm to another, and then hearing no evil, seeing no evil, speaking no evil, just ignoring how it's done. So with respect to the direct negligence, again, it doesn't matter who is doing this work. It's going to be extremely dangerous because these precautions aren't taken. They also, PacWest also knows that it's not going to be Clark Fork who does this because they can't because of their religious convictions. Incidentally, and somewhat ironically, their religious convictions do allow them to operate this crane, so they just do that now and they have the steel dunnage. So an entity like Wild Horse isn't necessitated anymore, but at the time they knew that it would be. I want to talk about I'm going to reserve some time, but I do want to talk about a couple of the cases that were relied upon, Dvorak and Dick Irvin. Dick Irvin's the easiest to deal with quickly because in Dick Irvin, the state generally had no knowledge that this paving work was happening. It didn't engage anyone, had nothing to do with it. The state didn't act in Dick Irvin. This is very different. We do have an admitted contractual relationship. Getting to your question again, Justice Baker, while there is an admitted contractual arrangement with PacWest, and they say they have no control over them, I mean, that is, you know, an independent contractor relationship. I mean, that is what that is. I think where the district court was misguided was the focus on, for any of these aspects, that there must be, and this seemed to be the tipping point for the district court, whether there is exercised control and whether PacWest held itself out as being a representative of, Clark Fork held itself out as a representative of PacWest. Well, that's not the law. That's never been the law. That's not the tipping point in any of these cases. Dvorak versus Matador. I would direct the court to its decision in Sizemore. That's 246 Mont 37, which does discuss the outdated nature of the Dvorak case. Dvorak was decided before the major revisions of 703. It's pre-Busta, pre-Fisher. And setting that aside, this is an entirely different arrangement. We do have a contractual relationship here, more like Beckman and Paul. And Dvorak and Matador had simply no relationship whatsoever. Dvorak is an employee of Beal, whereas in this case, Steve Blanchard is an independent contractor of PacWest. PacWest sent him. PacWest does have more of a relationship here, certainly, than Dvorak to Matador. I'm running close to my reserve time. I've enjoyed your questions, but I'm going to, unless anybody has anything more for me right now, I'll reserve till the end.
Any questions from the court? All right, thank you, counsel.
Thank you.
Mr. Chief Justice, and may it please the court, Colin Phelps on behalf of Pacific Western Lumber, Inc., which I will refer to as PacWest. I'd like to thank the court for scheduling this for oral argument today to give us an opportunity to respond to some of the appellant's legal red herrings and misstatement of the facts. First, I'd like to start with the legal standard. This court has consistently held that where the evidence concerning the status of the parties is undisputed, the question of their legal relationship, be it master and servant or contractor and contractee, is one purely of law. That's the crux of the issue here, is the relationship of the parties. Turning to the legal red herrings, appellants have suggested in their briefing and in the argument today that if they were only entitled to more discovery, they could have found out more information to determine these issues. They made a Rule 56F motion before the district court. The district court denied that motion. In doing so, it held that they had failed to put forth any facts that they had hoped to learn. They have not appealed that decision. They have waived the right to argue that there's a lack of discovery, and they have conceded that the evidence in the record is sufficient for the court to make the determination today. The other argument that they're making, they're arguing that PacWest had a duty to provide Mr. Blanchard as an independent contractor, essentially with a safe place of employment. They made the same
That
argument.
microphone needs to be closer.
Yeah, whoever is controlling the mic, can you turn up the mic at the podium a little bit? Go ahead, Mr. Phelps.
All right. They're essentially arguing that PacWest owed a duty to Mr. Blanchard as an independent contractor for him to provide him with a safe place of employment. They made the same argument before the district court, and they also argued that Montana Occupational Safety and Health Act applied, and that was the way that liability was attached. The district court also addressed that argument, denied that argument. Appellants have not appealed that argument. But even if they had, no such duty exists. This court has addressed this point almost squarely. In Payette v. Moore, 324 Mont 249, which the district court relied on, that involved a situation where Mr. Payette, who was undisputedly an employee of Moore Trucking, so a higher level of relationship, employee-employer relationship instead of contractor-independent contractor relationship. More Trucking sends Mr. Payette to pick up a load of hay, the very large round bundles. While the truck is being loaded with the hay, Mr. Payette's arm gets caught in the tractor and is torn off. He sues More Trucking and says that they have a duty under MOSHA, the Montana Occupational Safety and Health Act, to provide him with a safe place of employment. And this court held that the loading zone is not Mr. Payette's place of employment. If he has any place of employment, it's inside the cab. And the reason for that, I think, is instructive. This court held the employer's control over or right to control the location of the injury is essential to determining whether that location is the injured party's place of employment. Obviously, without the right to control a location, an employer cannot make it safe. So what appellants are essentially arguing is that PacWest owes a greater duty to its independent contractor than More Trucking owed to its employee. Now,
Well, the control is a separate issue from inherently dangerous. I mean, we said in Beckman that in addition to the inherently dangerous activity exception, an employer can also be liable for the torts of an independent contractor where the employer negligently exercises control. I mean, those are clearly two distinctive situations. Control basically would abrogate the need for showing an inherently dangerous condition. I mean, if you have control, then that's direct negligence. The inherently dangerous condition is the vicarious liability for the actions of the third party.
Great question, Justice Shea, and I'd like to address that. So, in terms of, first of all, this court has held that the inherently dangerous activity needs to be applied narrowly. That's Beckman, paragraph 25. If we look
There's no dispute here that this is an inherently, I mean, this was the example that was used in Beckman in addition to the trenching. I mean, there's not really a dispute here that there was an inherently dangerous activity going on here, is there?
I'd respectfully quibble with that a little bit. This isn't the same activity that's in Beckman. The Beckman example was the actual hauling of the logs, where in this case, Mr. Blanchard, as the independent contractor, PacWest could be held liable if Mr. Blanchard, negligently failed to strap it down and the logs fell over and injured someone. We've got that independent contractor relationship. Hauling logs is inherently dangerous, and PacWest's liability arises from their contractor's negligence. And this is the important distinction, and this is what the restatements say. You look at 416. One who employs an independent contractor to do work which the employer should recognize as likely to create during its progress a peculiar risk of harm to others, unless special precautions are taken, is subject to liability for physical harm caused to them by the failure of the contractor.
In that example, Blanchard being the contractor.
Correct.
Okay.
417, also same language. Special danger to others is subject to liability for physical harm to others caused by the contractor's failure to take reasonable precautions. Beckman, that an employer is vicariously liable for injuries to others caused by a subcontractor's failure to take precautions. The failure is on the contractor. Now, the appellants have argued that there's this second species under Beckman. So Beckman argued that Butte Silverbow had a duty to contractually require its contractor, in this instance Simpson, to provide for certain precautions. Again, we're looking at the contractor, and this second species comes from Restatement 413, and that provides one who employs an independent contractor to do work which the employer should recognize as likely to create during its progress a peculiar risk of physical harm to others, unless special precautions are taken, is subject to liability. Again, we are looking at the contractor who employs the independent contractor. It is the act of that independent contractor that causes the damage. Appellant's argument is essentially that PacWest is liable for Mr. Blanchard's injuries due to Blanchard's failure to take precautions. That's the relationship. Under their theory, PacWest is liable to Blanchard for Mr. Blanchard's own negligence. We got to look at the relationship between the alleged contractor and the party that caused the damage. And I think that's a very important distinction.
No, and I agree, and
I'm
I'm sorry,
I'm
go
sorry,
ahead.
can you back that up a minute? Because you talked about Mr. Blanchard's negligence, and I was making another note, so I wasn't clear about what you were saying there. Because it's Clark Fork's negligence that is the issue in the case. And so what you're saying is the restatement sections would apply only if it were Mr. Blanchard's negligence that were at issue in the case?
No, that's not exactly what I'm saying, Justice
I
Baker.
figured-
What I'm trying to address is the appellant's argument that PacWest somehow breached a duty under their theories, the negligent selection doctrine and the inherently dangerous activity doctrine, by sending Mr. Blanchard to there in the first place. So then the operative relationship is the relationship between under the restatements, the operative relationship is the relationship between the contractor and the independent contractor that caused the damage. In this instance, Mr. Blanchard didn't cause the damage. What I was trying to say by saying that Mr. Blanchard would be liable for his own negligence is that their argument is essentially PacWest is liable for Blanchard's injuries due to Blanchard's failure to take precautions. I mean, that's what their argument amounts to, because the restatements force you to look at the contractor and the one who caused the damage. So they'd have to argue that Mr. Blanchard caused the damage.
So why isn't, I asked Mr. Stalpas if Clark Fork was an independent contractor of PacWest, and he said yes. Is your answer the same?
No, our answer is
Why not?
emphatically no. There's several different reasons for that. First of all, let's be clear about the contract we're talking about. We are talking about a purchase order, a handwritten purchase order.
Well, there wasn't even that in Beckman between Quinlan and Butte Silver Bow. There wasn't even they just verbally agreed that he could do the trenching.
Well,
And I want to back up, though, for a second, because I think it is important, and I think that the way I see it, and this is not a rhetorical question, I want to correct me if I'm wrong, is I see it, as I read the restatement, is I think that the inherently dangerous condition fills two different roles, if you will. I think that when you're talking about the direct negligence, it's the foreseeability role, that PacWest whether they were out on the site and they saw the conditions, and so it was reasonably foreseeable that Blanchard could be injured. And that's the direct negligence. The inherently dangerous condition is the vicarious liability, is the way I see it, is that if it was an inherently dangerous condition, rather than being a foreseeability issue, the inherently dangerous condition is where the vicarious liability comes in for the negligence of the subcontractor or contractee, or however you phrase it. Is that correct, or do you read it a different way?
I read it differently, Your Honor, and respectfully, with regard to Beckman, I respectfully disagree that there wasn't a contract. There's an agreement between Butte, Silver County for this contractor to install a city water line. They had to get a permit, they had to have their plans checked, they had to build pursuant to the specs, and the Butte Silver was able to observe the actions. And then at the end of the day, Butte Silver reimbursed them for the costs. So there's a contract there. Whether it's oral or written, there is a contract there.
Well, but I know, but you're relying on a purchase order that doesn't fit the bill. So, I mean, if that's something written. I mean, and I guess the thing that I'm wondering here is when you talk about the relationships of the parties, and this is where I think I get hung up on the labels being less important than the nature of the relationship, because you speak at length in your brief about and the district court relied upon this, about there being no agency relationship, that Clark Fork wasn't an agent, and all of this. The word agent or agency does not appear, much less a discussion of agency or ostensible agency or anything, doesn't appear anywhere in the Beckman opinion. So it just seems to me, it just seems there are two questions: the nature of the relationship and whether it was an inherently dangerous condition. And I guess where this leads me to, where I'm questioning, because we're here on summary judgment, is how aren't those fact issues? Whether there was nature, whether there was the relationship, the nature of the relationship writ large, without getting into the labels per se, is one issue for the jury to decide, and the other issue for the jury to decide is whether this was an inherently dangerous condition. I mean, you allude to the fact that the example in Beckman is different from the example here, and that's a fair point. But I mean, it seems to me that it's a question. It's a question of fact, whether it was an inherently dangerous activity or condition.
I believe in Beckman, the court held that inherently dangerous activity can be decided as a matter of law. And going back to the restatements and these relationships, because it does all hinge on the relationships, both 416 and 427, the liability arises based on the failure of the contractor to exercise reasonable care. So we're looking at the contractor. With regard to your question of, the label of, we have a written purchase order here, why isn't Clark Fork Post an independent contractor of Pac West? I think we first need to go back to some of the appellant's factual misstatements. First of all, they asserted in their briefing and at oral argument that Pac West business partner, Frontier Post, admitted Pac West knew about the conditions at Clark Fork Post site. What they've cited to is Matthew Troyer's deposition testimony, who is the owner of Frontier Post. He doesn't say anything in that cited about Pac West knowing anything. What he says is it was his opinion that the equipment that was being used was inappropriate. The next factual misstatement is that Pac West lumber sales supervisor Steve Warren witnessed dangerous conditions at CFP at Clark Fork's facility. Mr. Warren and James Yoder, the owner of Clark Fork Post, both testified under oath that the purpose of the visit was a sale call. It lasted less than 1 hour, and Clark Fork Post was not operating at the time. Mr. Warren also testified that he didn't observe the conditions, was there to introduce himself and see the quality of the product. There's nothing in there about Pac West knowledge. That's pure speculation, and that doesn't rise to substantial evidence. The next argument, or misstatement, is Pac West should have known Clark Fork Post didn't have insurance or use equipment because they were Amish. Mr. Troyer, the owner of Frontier Post, also testified that he's Amish. They use the exact equipment that appellants suggest Clark Fork Post should have used. Mr. Troyer also testified that they have insurance.
And I'm not trying to be glib here, but isn't there, I mean, when somebody is Amish, and we may have our misconceptions, and certainly, every religion has their lapsed members, but when you know that somebody is Amish, at least wouldn't that be some sort of inquiry notice? If you're aware that there is certain equipment that is necessary to perform an activity, and you know that the party that is, the religious belief of the party is not to use mechanical activity, wouldn't there be some sort of a notice that, if they're not using a cherry picker and they're not using dunnage, that might be something we want to look into?
I guess the point would be that I don't think you can assume that just because someone is Amish that they don't have that equipment. And the use of the equipment, respectfully, I don't think ultimately matters. We've got to look at the relationship. And going back to that, the appellants have said that Pac West ordered production of logs from Clark Fork Post. Pac West did not order production of logs. The citation that they cite for that proposition is their own discovery responses. The undisputed material facts from Mr. Warren and Mr. Yoder, both of whom are the people who would have that knowledge, is that Pac West places a purchase order. There is no contract to mill and produce logs. It is a contract to purchase a product. Clark Fork Post sells a product in wholesale to retail and local customers, and Pac West is not their only customer.
Counsel, I know you're probably still going to go through more disputes, but you at one point were asked whether you thought Blanchard was an independent contractor or a contractor, and I don't think you got through the question.
Oh, excuse me, Your Honor. Mr. Blanchard is undisputedly an independent contractor of PacWest. There's no dispute
Yeah, the
about that.
question was about Wild Horse? Your question, Justice Baker?
No, I think you answered my question. It was about whether Mr. Blanchard's negligence was some kind of issue, but you answered that.
Okay. And bringing up Wild Horse is a great segue because the appellants are focusing on the wrong entity here. Again, as I talked about earlier, and if we look at the negligent selection doctrine, that provides that an employer is subject to liability for physical harm to third persons caused by his failure to exercise reasonable care to employ a competent and careful contractor. Negligent selection doctrine requires that contractor-independent contractor relationship. The citation to Swift, those facts are distinguishable. There, Swift retained an independent contractor, the towing company, to come pick up the truck. It was the towing company's failure to use reasonable efforts to load that truck that resulted in the injury. And that's where it comes from. And
Do
again,
you have an ongoing relationship with the towing company in Swift? I mean, that was a one-off. I mean, how is it different to hire a towing company to come out and, tow a car and that establishes that relationship than sending somebody to even, pick up a load of logs, much less repeated loads?
well, I guess the relationship again that we're focused on is between PacWest and Clark Fork Post. And that, they have to establish that that's an independent contractor relationship. And they haven't done that. And then, as I was saying earlier, the inherently dangerous activity doctrine, we're again looking on the contractor who caused the damage, the contractor's failure to exercise reasonable care. In this instance, the contractor who allegedly failed to exercise reasonable care is Wild Horse entities. It is beyond dispute that PacWest has zero relationship with Wild Horse. Mr. Weirin testified that he'd never heard of him before. Mr. Yoder testified that PacWest had zero involvement, and Wild Horse's discovery responses and their deposition testimony state that they weren't working for PacWest. They were working for Clark Fork Post.
Well, how does the non-delegable duty aspect of it come into play then?
Could you?
Well, I mean, they alluded to, and it was discussed, that if, just assuming for the sake of argument, if there was a contractual relationship between PacWest and Clark Fork hired Blanchard, or not Blanchard, excuse me,
Wild Horse.
yeah, Savage. But there is the issue of that they couldn't delegate their duty, if there was a duty, to Mr. Blanchard. That was non-delegable, wasn't it?
Yes, but again, you need to establish that contractor-independent contractor relationship.
No, and I understand, but you're saying that somehow breaks the chain. And what I'm saying is, if we assume, that's why I prefaced it with, if we assume for the sake of argument that there's a contractor relationship between PacWest and Clark Fork, and Clark Fork can't delegate its duty to Blanchard and escape that way. And I mean, I understand it's the connection there, because if they can't delegate that duty, then they themselves, Clark Fork, would be liable. And if they are liable and there is a contractual relationship between PacWest and Clark Fork, then PacWest is vicariously liable for Clark Fork's negligence, correct?
Under that hypothetical, potentially, but again, that hinges on, there needs to be more than just that contractual relationship. And I think the workers' comp framework and the administrative rules are instructive here when we're trying to decide who is an independent contractor. And for example, ARM 2435-303, the independent contractor guidelines, uses performs services 11 times. An independent contractor is someone who performs services for the other party. ARM 2435-101 defines hiring agent as the entity that hires an individual to perform services. PacWest is not a hiring agent that retained Clark Fork to perform services. It's Clark Fork's customer. Clark
I mean,
Fork
the
testified.
work comp, we've never used those in any, I mean, for purposes of outside of the work comp arena.
Well,
Correct.
and just to follow up on that, that definition that you just read seems consistent with the definition of an independent contractor that's used in the restatement. Comment A to section 409 defines an independent contractor as any person who does work for another under conditions which are not sufficient to make him the servant of another. So, and then gives the example of engaging the other to undertake activities on behalf of Company A and its relations with third parties. So are those the same or different definitions of the independent contractor? And was PacWest engaging Clark Fork to undertake activities on its behalf or to perform work for PacWest?
No, PacWest was not engaging Clark Fork to perform work with it. They didn't have a contract for PacWest or for Clark Fork to mill the logs. They had a purchase order. Clark Fork mills posts and poles as its normal course of business. It sells it to local customers retail and wholesale customers commercially. Clark Fork is essentially PacWest material supplier. A material supplier does not enter into a independent contractor relationship with its customer. It enters into a commercial sale. Clark Fork Post doesn't perform services under PacWest's direction. It manufactures goods and sells them at arm's length. And I think it's important, under appellant's theory, a landscaping company that regularly purchases trees from a nursery could be held to be liable for those conditions. The nursery could be held to be the landscaper's independent contractor. The road construction company that regularly orders gravel and road mix from the quarry could somehow be held to be their independent contractor. In the Payette v. Moore case, a rancher who regularly purchases hay from a farmer could be liable for the conditions at the farm. Liability just does not attach based on based on purchases. They have to engage them to perform a service. Now, I understand the argument that they're saying that loading logs is performing a service. Well, under appellant's theories, they would expect PacWest to have its own loading operations at the dozens and dozens of independent post and pole mills around the country or around the Northwest that it purchases its product from. Briefly, I'd like to touch on a couple other factual misrepresentations. The loan occurred after, and the loan was not to purchase the safety equipment as implied by appellants. Both Mr. Wern and Mr. Yoder, the parties to that contract, testified that that loan was from PacWest to Clark Fork Post to purchase product, to purchase material from independent loggers that it purchases its logs from. It occurred on August 18th, 6 days after. They both testified that's the purpose of that loan. Clark Fork has paid that back. Those loans in this industry are common because these small post and pole operations usually lack the commercial capacity to be able to purchase raw material. But again,
That being the first loan?
Yes, that was the first loan. So stepping back to PacWest and Clark Fork's relationship, PacWest is a lumber wholesale distributor. It purchases the logs all across the Northwest. Both Wern and Yoder testified that when PacWest wants an order, Mr. Wern either sends an email or picks up the phone. Yoder makes sure that he has product to fill the order and calls Wern to ship. If Clark Fork Post doesn't have product, PacWest purchases it from another supplier. Mr. Yoder testified, if PacWest doesn't purchase from it, he'll just sell that product to someone else. He cuts set lengths. This is not a special order. It's the set lengths. This is the lengths he cuts. This is his product PacWest purchases.
On that point, though, is it, and I wasn't clear, is it true that PacWest purchases at least the majority, if not the bulk of Clark Fork's product?
Yes, Mr. Yoder testified that that's
Yeah,
true.
okay, thank you.
So
So I guess on that note, lots of times loading logs. Is that fair? A lot of times at PacWest, subcontracting haulers have loaded logs at that facility, had logs loaded at that facility. Is this the first accident?
I'm unaware of any other accidents. There's no other mention of any other accidents. I mean, I understand that Mr. Blanchard had been there a few dozen times.
Okay.
PacWest had been using Mr. Blanchard. I can't remember the length. It's in the briefing before the district court.
Okay, so Mr. Stoppes had indicated that the yard condition was inherently dangerous and they knew about it, and it goes to the level of, I guess, the scope of foreseeability. So I'm thinking, well, is this the 10th accident from loading them wrong, or is this the first?
I believe Mr. Yoder testified that it's the first, that he never had it. So, and I'd also like to talk about some of, the appellant's cases that they point to for the proposition that just because there's a lumber company and a mill here are different, they all involve services. In Parkinson, buy, cut, and remove logs. Parrish contracted with the Sawyer to saw timber and deliver it to the planing mill. Copeland, the timber company, contracted to set up a mill, deliver the logs. In closing, while the district court may have analyzed it under an agency principle, the district court's conclusion is ultimately correct. The legal relationships upon which appellants' theories rely are simply not there. You know, this court is well aware that it's regularly held that they will uphold the district court if it reaches the right conclusion using the wrong rationale. And thank you very much.
Any further questions for counsel?
Thank you.
Okay, thank you.
I'll start whenever you tell me, Aaron. Good, okay. Thank you again, Chief Justice. Just take a step back and think about this logically. There is a dangerous service at issue, which is the loading of these logs onto the semi-truck. That is part and parcel of this. Wild Horse ultimately was paid for that service because it's a service. Logically, I mean, what's happening here is, so PacWest sends Steve Blanchard to the site with just a semi-truck. He can't load these. This is the responsibility of Clark Fork to load these, and it's dangerous to do that. Clark Fork can't, so it subcontracts down to Wild Horse because this is a service. It's built into the price. And to say that they don't have a contractual arrangement because there's a purchase order, there's nothing with Steve Blanchard. They just call him and tell him to go. But yet he's an independent contractor. The arrangement with Clark Fork directly contemplates dangerous work, which is the loading of these log bundles. They say that they would be liable if Steve Blanchard did something wrong during that loading process, but not PacWest, whereas the district court determined, or not Clark Fork, and the district court determined that, well, Steve Blanchard's not, he doesn't have any role with respect to the loading. He's an independent contractor of PacWest, but he's not responsible for any of that. And of course he does. He's out there having to ratchet these down to make sure the load is safe because they don't have the steel dunnage. And as far as the open and obvious nature of this, it's not as if you can miss a crane. These are not movable, drivable objects. That's why the Amish can operate them, as was discussed earlier. This is a crane that sits at the loading area and then picks up the bundles and then places them over the edge of the steel dunnage and places them down. That's the way this is typically done and the way it's done now at Clark Fork. I think we have somewhat of a concession here that the district court's rationale was not quite correct. One of the ways that's perpetuated is we have a misstatement of the law from Paul. PacWest has continually stated, and here's the quote from Paul, is the first step in applying the law to the county is determining whether it was in a contractor-independent contractor relationship. That's what we've talked about, and I'll come back to that with what little time I have. PacWest changes the language whenever it cites it, and this was picked up by the district court. This is the quote from Paul used by PacWest in the district court. The first step in applying the exception to PacWest is determining whether it was in an agency relationship with the tortfeasors. That's just it just directly takes the law and changes it and applies a different test. The district court applied the wrong test. That's why it needs to be reversed. As far as Wild Horse goes,
Well, but
Yeah.
Paul said the first step is the contractor-independent contractor relationship.
right,
And so that's, the relationship is the key here. And I guess the PacWest's argument today is that there is no independent contractor relationship because Clark Fork was not providing a service on behalf of PacWest. It was supplying its product to PacWest. And the reason it's important that Mr. Blanchard was an independent contractor is because he was providing a service on behalf of PacWest, which was to deliver logs. Do you see those as two different relationships? And if not, can you explain?
they're overlapping relationships. There's a Venn diagram here that overlaps. And I'll pose this again. Steve Blanchard is providing a service, we all agree there, in transporting these logs from Plains down to the preservative mill or treatment plant, right? Somebody's providing the service to pick those logs up and put them on that truck, which is the most dangerous part of this entire arrangement. I mean, even what Mr. Phelps is talking about with, well, yeah, that's what's inherently dangerous is if Steve doesn't ratchet them down. That's during the loading process. Everything that Beckman is talking about, everything that the restatement illustration 2 and 411 is talking about is how dangerous it is to transport these logs. And the reason it's dangerous is because everything has to go perfectly during that loading process. That's the issue. When these things are driving around, if the loading process doesn't go well, these logs can cascade off the truck, or somebody can get hurt during. This is the dangerous part of this. So what's the service? So Steve Blanchard is responsible for taking a loaded truck and driving it down to Stevensville. And they want to say that, well, PacWest, all they do is just mill these logs and we just buy them from them. But somebody's responsible. Somebody does this for PacWest. Somebody picks up those logs and puts them on Steve's truck because they don't pay Steve to do it. Steve doesn't have the capacity to do it. There are trucks, and certainly PacWest has seen these, that have a crane built upon them that can lift them up onto their set steel dunnage, but they didn't do that. They chose a trucker, less expensive than a trucker who would have this equipment, this unique specialized equipment, and said, all you got to do, Steve, is drive these things for us. And we all agree that even though there's no paper trail, there's no master service agreement, that he is an independent contractor because it's a service.
The purchase order that Mr. Phelps showed, that's in the record that's before us.
It is in the record, and what it says is, it's a purchase, and it says transport to Mill Creek, or the mill, right? That's the purchase order. It says, so it has the specs, and then it says deliver. So this is PacWest writing to Yoder, deliver to Stevensville. The delivery is in the purchase order. It's in the note.
So is the distinction then between a typical customer-retailer relationship and this, that if I were to go to Lowe's, I typically go there with my own car and I buy something and I carry it to my car and I go home. If I buy a big load of lumber, the inherent in my purchase of the lumber is that somehow it has to get loaded onto my truck. Even if Steve Blanchard's out of this is my truck, somebody's got to load it.
Yeah.
And that is what you're claiming is the inherently dangerous activity, the loading part of it. It's impossible for me to buy lumber from Clark Fork without it being loaded. That being loaded is part and parcel of the purchase.
Yes. And I don't want to get too tied in with just the Lowe's analogy here, because what we have here is very different, because the equipment that's used for something like this, and this is why we disclose those affidavits from Larry Reinholtz, who's a professor in Butte, and the former OSHA investigator from the area, is that this is different. I mean, the size of these, and because they're bundled up and circular, they're prone to rolling, they're banded, those bands are prone to.
That's why, I think the Lowe's example is not analogous to this
Yes,
at
yeah.
all.
Right,
Is
right.
why I said it, is that there's no way I can get a load of lumber from Clark Fork without it being loaded.
Yeah.
It has to be loaded.
Yeah, and we draw these distinctions in severity and degree all the time in the law. In Beckman, for example, trenching is an inherently dangerous activity, but only if it's more than 4 feet. It's only when the trench box is required. Heights can be an inherently dangerous activity, but it depends on how high, right? I mean, we don't hold people responsible for a step stool, but we do for scaling buildings, right? So there is a difference in degree and nature, and there is a service here, and it is the most dangerous service involved in this entire chain. It is the moving of those logs, those bundled up, banded logs that are 7,000 pounds apiece, and we're loading 12 to 14 of them onto a flatbed semi-trailer. That's dangerous, and there are engineers with degrees and machine operators and machine manufacturers who make money designing things just for this very purpose, and they exist on the site now. It's the lack of those standard precautions, which PacWest, these are open and obvious. They had inquiry notice. They deal with this all the time. They should have known.
Just want to.
Yeah, please.
I mean, because, and I asked Mr. Phelps this, but I want to, because I think this is where some of the confusion, at least for me, arises, is because you just alluded to, we've got the inherently dangerous activity. That requires some sort of contractor relationship, and that's the vicarious liability for the negligence on behalf of the contractee or subcontractor.
Yes.
But you talk about it, and I think it's just using shorthand, the dangerous condition of the yard and the knowledge and foreseeability, that necessarily is the first person, for lack of a better way to put it, negligence.
Yes.
Correct? Okay.
Yes, yes. It serves two purposes. I think you alluded to this earlier. The inherently dangerous activity brings you into one of the exceptions to the general rule in Beckman, the sole exception that does not reference control in any way. So
And the other two exceptions just don't apply. The other two Beckman exceptions don't apply here.
Probably not,
All right.
to be honest. On the direct negligence chain, yes, that gets to, this is just the foreseeability nature, because these are so standard in the industry, lack thereof.
All right. Thank you, counsel.
Thank you.
I have one question.
Go ahead.
I guess, do you disagree with PacWest's take on, we spent a lot of time here talking about 416 and 427 and their applicability, and any thoughts on that?
Thoughts on whether Section 416 and, sorry.
Well, PacWest's attorney got up and told us all about why 416 and 427 basically preclude liability because all of the negligence had to have been on the part of Mr. Blanchard.
If you look at the hypothetical, it has party A and party B. His argument is under that, if that's applied here, party B would be Mr. Blanchard causing injury to a third party. So he says basically that hypothetical, or that example, illustration doesn't fit here. What's your thoughts on that?
Oh, it applies with respect to Clark Fork.
You're saying Clark Fork is party B?
Yes, yeah, Clark Fork is party B. So the analysis with Steve Blanchard, that's a jury question. That's comparative fault. That's for another day. The issue, and Justice Baker hit on this right away from the Paul case, which is basically sections 416 427 and 413 will all apply. 413 is the restatement section in the absence of contract. So we have absence of contract 413, 416 is special precautions with a contract, 427 is the same for special precautions with a contract. All right. But nevertheless, to implicate any of these, we look at whether there's a independent contractor-contractee relationship. What we're looking at is whether one is entrusting another to perform an inherently dangerous service or activity. That's really the crux of the question. So what the court needs to decide is, on the vicarious liability aspect, whether there's a question of fact or sufficient evidence to establish either one, that PacWest entrusted Clark Fork for this act of loading. Now, they didn't pay Steve Blanchard to do it. They didn't bring anybody else in
Right.
to do it.
Okay. Thank you.